Senior police officers are to lose the power to self-authorize access to personal phone and web browsing records under a series of late changes to the Snoopers Charter law proposed by ministers in an attempt to comply with a European Court ruling on Britain's mass surveillance powers. A Home Office consultation paper published on Thursday also makes clear that the 250,000 requests each year for access to personal communications data by the police and other public bodies will in future be restricted to investigations into crimes that carry a prison sentence of at least 6 months. But the government says the 2016 European Court of Justice, ECJ, ruling in a case brought by Labour's deputy leader, Tom Watson, initially with David Davis, now the Brexit Secretary, does not apply to the retention or acquisition of personal phone, email, web history or other communications data by national security organisations such as GCHQ, MI6 or MI5, as national security is outside the scope of EU law. The new safeguards involve fresh amendments to the Investigatory Powers Act, described as the Snoopers Charter, and follow the ECJ ruling, which said the general and indiscriminate retention of personal communications data cannot be considered justified within a democratic society. The European judges ruled that such mass harvesting of personal communications data could only be considered lawful if accompanied by strong safeguards including judicial or independent authorization and only with the objective of fighting serious crime including terrorism. Davis, before withdrawing from the case when he became a minister, argued that the government's approach to collecting communications and other personal digital data amounted to treating the entire nation as suspects. However, Watson said the Home Office concessions were flawed and did not go far enough. The current legislation fails to protect people's fundamental rights or respect the rule of law. That's what my legal challenge proved, and I am glad Amber Rudd is making significant concessions today. But I will be asking the court to go further, because today's proposals from the Home Office are still flawed. Ministers aren't above the law, they don't get to pick and choose which rights violations they address, and they can't haggle with the courts to avoid properly protecting people's freedom. All of the fundamental safeguards demanded by the court must now be implemented. Communications data covers the who, where, when, how and with whom of a phone call, text, email or web page visit, but does not cover the content of those exchanges, which is covered separately by interception laws that require ministerial authorization. The proposed safeguards, which are the subject of a 7-week consultation, include: the Security Minister, Ben Wallace, said communications data was used in the vast majority of serious and organized crime prosecutions and had been used in every major security services counter-terrorism investigation over the past decade, and its importance could not be overstated. For example, it is often the only way to identify pedophiles involved in online child abuse and can be used to identify where and when these horrendous crimes have taken place, he said.